All right, I have news. We're going to begin. Welcome to our first ever bi-county technological hoopla seminar. Very excited about this. I do want to make a shout out to everybody in the Ninth Circuit, our technology gurus who made this happen. It sounded like a fabulous idea a couple of months ago when we were only chit-chatting about it. I think the last couple of days, everybody's been sorry they told me yes, but you made it happen anyway. Thank you, Matt Bettafield, Lee Alexander, J.R. Denman. I know, J.R., you miss me. No, he doesn't. And to our Help Osceola team, thank you very much. And the guys here today, Navajo, Darren, and Ryan, thank you very much for letting us get this actually up and running. We're going to do things a little bit differently than we have at past seminars, just because we do have kind of two fronts going on. So one of the things that we're going to try to make sure that we do so that everybody gets the most out of this on both ends is that when questions are asked, we need to be repeating those questions back from here and from Judge Traver's podium. So help us remember to do that. I'm going to introduce to you our cast of players. Obviously, I'm Judge Tennis, you know me. Welcome. We have in Orlando, Judge Dan Traver. Dan is currently in the DV bench. He also does associated family law cases. He is a brainiac. And as the seminar goes on, you will come to be wondering why it is you've been listening to me all these many months when you could have had the star power of his caliber. So thank you very much, Judge Traver, for helping us out.
Thanks, no pressure there.
Here on this end, I have my cohort, Judge Barber. As you know, she and I divide equally the domestic bench down here in Osceola County. And I like to think we're peas in a pod. We really have a great time serving the folks of Osceola County and the family divisions.
No, you're the yin and I'm the yang.
Yeah, that's true. That's true.
Something.
That's true. That's true.
We're opposites.
We also have here back to help us on this very important, meaty topic of Department of Revenue cases, Hearing Officer Norberto Katz. He's here in Osceola County and he hears child support cases involving the Department of Revenue. And as we get further into the seminar, you're going to learn a lot more about what he does, why it's so important for you to know what it is that he does. Thank you very much for being with us, Mr. Katz. We also have Attorney Hernan Castro. Hernan does all of the Department of Revenue related child support work here in Osceola County. Is this the only county?
Brevard and Seminole.
Okay, so Brevard and Seminole. So he gets all over the place, frankly, and you're going to learn a lot more about what he does for the Department of Revenue also. What we're going to do today in order to make sure that we, again, get those questions heard by everyone is we're going to cut this up into sections. And at the end of each section, we will open up questions. And then at the end, hopefully we'll have a few minutes and you can ask questions you might have not got fit in along the way. We're going to start with talking about Department of Revenue related issues. And Judge Barber and I have learned so much since we last covered this topic. I think that it will be a little bit easier for us to hone in on the areas that we continue to see problems, issues, and the areas that we really feel are going to be the best for you. So rather than have Mr. Castro and Hearing Officer Katz kind of lecture you about that, we're going to do a little bit more of a Q&A so that we can hopefully get you the information that you need and all of the information that you really need. So Mr. Castro, I'm going to start with you. Your office, when you sign a pleading or file a pleading in a child support related case, who is it that you represent? Is it the Department of Revenue? Is it the person who wants to get paid money? Who is your client in those situations?
The client of my office is the agency, the Department of Revenue. We represent the agency and not any one of the individual litigants. The agency has to provide services to the different parties according to the rules. But my loyalty, the entity that I represent is the agency, the Department of Revenue.
Now, when I talk to litigants and lawyers in the courtroom, the words that I use when I run into a child support should be in front of Mr. Katz, and it's a Department of Revenue child support case. I throw out this term a lot, and I think that there's a lot of unclarity about what it means. What is a Title IV case, and what does that mean, and is that the only type of case that you're involved in?
The only type of case that I'm involved in is a Title 4D case. The case becomes a Title 4D case whenever the Title 4D agency for the state of Florida is involved in the case. So, whenever the Department of Revenue is providing services, any one of the number of services that it provides to either petitioners or respondents or defendant children, that becomes a Title 4D case. Title 4D comes from that section of the Social Security Act, which created the child support program and which is implemented throughout the entire United States pursuant to funding that comes from the federal government.
Now, if somebody, what kinds of support would be the most typical kinds of support that our lawyers are going to hear their clients talk about, and they can go, oh wait, I better check this support case?
If the person is receiving any type of public assistance, be it Medicaid, food stamps, cash assistance, they become part of the Title 4D process. Actually, at that point, they're part of the Title 4A process, which is the actual assistance part. But then the support obligation of those individuals becomes assigned to the department, and the department enforces whatever support obligation exists on the Part 4 of the Social Security Act, and that's how we come into play.
Can somebody come in and ask you to help them get child support even if they have not received any type of cash assistance or any other type of government assistance?
Yes, and that is under Chapter 409-2567. Now, normally, people come in under 409-2561 and 64, which is the assistance part. However, part of the child support program requires state to provide assistance to people who are not part of the public assistance aspect of the case, and they come in as what we normally call a non-assistance case. And we are required to provide the exact same services that we provide to someone who is on assistance.
And would that be considered a 4D case?
It is.
All right. So, how many of the lawyers here in Osceola County, do you have access to the dockets for the cases that you are involved in family court? I mean, can you go online and you can actually see all of the docket entries?
Yes.
All right. I don't know if that's the case in Orange County, but I would assume it is. So here, we're going to talk about some of the things you need to be looking for. Because the big picture that we're going for is, there's a whole lot of child support issues that need to be dealt with in front of the child support hearing officer that you all are trying to deal with in front of the circuit judges. Here in Osceola County, we are very tight about that. My understanding, although the rules are the same, the laws are the same, the structure that we're going to be talking about should be similar wherever you go in the state, certainly should be similar wherever you go in the circuit. My understanding is things may be a little bit more bendy in Orange County, things might not always necessarily get caught, but they're getting caught here. So here, let's talk about some of the things that the lawyers need to be looking for them to decipher when you all are involved. When you file a request for copies in a case that is a paternity or a divorce action, Mr. Pastor, what does that mean in effect?
That is actually the agency filing that. In Osceola County is called request for copies. That means that they have either received an assignment via computer from the 4A agency that someone is receiving public assistance and child support needs to be enforced, or someone has walked in to the department and asked for services on the 409-2567. In either one of those two circumstances, or we may have gotten a request from another state. In any one of those circumstances, the department will, especially if there is a case outstanding in court, request copies of the record from the clerk of the court. That's the entry that you see there, request for copies. That does not necessarily mean that the department will end up providing services. It just means that it is interested in the case because of one of those occurrences and is now requesting copies from the clerk of the court to determine whether it will provide for these services in this instance.
All right, so we're going to come back to that in a moment, and I'm going to ask Mr. Katz to address something. Before we get to my next question, which will be to you, Mr. Katz, when a notice of redirection gets filed, and there's two to look for, the notice of redirection where the department is getting involved, and the notice of redirection where they're getting uninvolved. Mr. Castro, does your office do the initial or the latter redirection in or out of the case?
No, the agency does that as well. Once the agency determines that it's going to provide services in a particular case, assuming that there is an active case, they will then do a notice of redirection, which redirects the support in that case from the individual petitioner to the agency.
Okay. And the important thing to point out about both of those documents that are getting filed in your paternity action or your divorce action is that they do not go to the lawyers. Now, those two notices theoretically, are they going to both the parties?
I believe that the agency sends them to the parties. I couldn't swear to that.
All right.
I think they do.
All right, so then, Hearing Officer Katz, let's start with the easy one.
Okay.
If any of these folks sees a redirection notice from the Department of Revenue in their paternity or divorce case that says, we are now providing services, what does that mean for child support issues in that case?
That means that any subsequent proceedings after that case becomes a Title 4D case have to be filed and heard by the child support hearing officer. Be they motions for contempt, any type of enforcement action, any type of modification action that ensues after that initial order has been entered.
All right, so say for a moment that, I hate to be sexist, but say for a moment, I won't be sexist, say for a moment Dad, who has primary time sharing with the children, has gotten assistance, say the department, and there's a paternity case pending, or say there's a divorce case pending. The department files a notice of redirection in the divorce case that's ongoing, both parties have lawyers, and says we are now involved in the case. What if mom or dad, what if dad, who has the children, wants his lawyer to take care of child support in front of the circuit judge and not take it to the hearing officer?
Well, again, that if DOR has filed that notice, that means there's some type of services being provided. Your client should be advising you that they have asked for services from the Department of Revenue. That should be your first goal. But any support issues that arise out of that case have to be heard by the hearing officer, because if and this is the issue, because if the attorneys go to the circuit judge and don't go through the hearing officer, there are vested state interests that they may be circumventing. There may be cash assistance being paid, other type of assistance, and that is recoverable through the efforts of the Title 4D process. So it's very important that that happens.
So are there situations where the redirection may come up in the paternity or divorce case and there's never actually a separate case opened by the department in front of you?
That's very rare. Most of the situations that we're facing currently are situations where support has been established through the Title 4D process, and then the parties are not married in a husband or wife situation, or the parties are married and then one of the parties comes back to do a time sharing, files a time sharing petition, and child support is dealt with in that second case. That's where the problem really lies. And then if the child support provisions are not heard by the hearing officer, you may have competing orders. That's really what the crux of the issue is.
And I just want to underline and highlight that is the crux of the issue. So if there is a old child support case and the lawyers are not notified of its existence, and I dare say this has happened, and the parties then have some type of family case proceeding in front of the circuit court and do not include the department or don't go back to the hearing officer for the child support, A, what happens, and B, what's the fix when it gets figured out after the fact?
Well, what happens is, in many cases, and we've dealt with this, you've got competing orders. You've got basically two child support orders. And so the payor is paying in two cases, or he's being assessed in two cases. And the important thing to note is where this problem really comes up is when the initial case, which is usually the Title 4D case, is on the radar with DOR, and DOR starts enforcement proceedings because the payor is paying the second case where DOR is not aware of it. The fix is rather difficult because you have two competing orders. I guess the easiest fix is you would go back, you would set aside any support provisions of the second judgment, the one that DOR is not involved with, and then ask for a hearing to determine what arrearages, if any, is owed in the first case, and hopefully give a credit for whatever payments were made in the second case. And we've had that
But
situation.
you're speaking though of a case where the support was established in the DOR case.
Right.
But not to a situation where there was a divorce granted and the DOR got in after.
Yeah, that's a separate issue.
issue.
Yeah, that's a whole separate issue.
All right, so what if there's a DOR proceeding, but there hasn't been a child support order yet, and the parties come in with an agreement that they do not include the department in, because it's a rarity that I see people include the department in the agreement that they came to on child support, even if there's an open DOR case in front of the hearing officer. So say for a conversation, they don't let the department know. Now they've got this order in family court saying child support's going to be $200 a month. You've got an open case. What needs to be done at that point?
Well, that's really kind of, I don't want to punt, but it really goes back to Mr. Castro because the department has to determine, and it's really up to the department to determine, do they want to dismiss the DOR case at that point because support's been established? Do they want to intervene in that other case to decide that that order should be set aside? Or do they want any other kind of relief? Because the department, and this is a problem the attorneys really should be looking at, is that if they get that second order, the one you're talking about, when there's a pending support case that's pending before our area, we don't know about it until it gets to a hearing. So it'd probably be good practice if you're setting support to make inquiry where there's an existing DOR case, and at that point contact Mr. Castro's office if he's appearing and advise him so that he can then notify DOR and get a decision as to how they need to proceed.
So, I'm talking about the extremely rare situation that you're going to have in Osceola County, and perhaps, I don't know how common you might in Orange County, Mr. Castro, that you will have a pending DOR case that has not gotten to a final order, and there is an order on child support based on agreement, hearing, whatever, in the circuit court case. If that is sent to you, what do you do with that at that point? Say two different scenarios. One is you guys are good with the child support as it was agreed to, or two, you don't agree with it.
Right. And the only time that the department would not agree to a mediated agreement or something like that is if the state's interest has been ignored. Say, if there is public assistance that has to be paid during the period of time that retroactive support should have been calculated. And the parties decide, for whatever reason, that they want to waive any past due child support at the time that they enter into the agreement. Now, you've got some assigned rights to the state of Florida, which is the child support that was owed during that period of time, according to the child support guidelines. If that has been assigned to the state, then we will say, no, you cannot get rid of the retroactive child support.
Now, when you say yes, is there anything that happens automatically in the DOR case to adopt, accept that agreement and order from the circuit court case?
I can answer that. No, what typically happens is Mr. Castro will not find out until the hearing. That's typical. We kind of find out things as we go along many times. So the parties will come in and say, but we have an agreement, or we have this order for support. And then I turn to Mr. Castro or whoever's sitting in his place and ask, does the department want to proceed? And I have to figure out whether I can proceed or not. Typically, if there's no state benefits, as Mr. Castro just told us, if there's no issue about retroactivity for repayment of benefits, usually we just dismiss the DOR case and the parties can proceed in the other case.
Now, how would you find out about that order if nobody thought to send a copy to the department?
Well, we've started, and I have to give kudos to my trial clerk, because she does a very thorough job at the hearing or prior to the hearing to see if there's any related cases. And she'll let me know if there's any issues, and I'll double check the benchmark also. So between her and Mr. Castro and me, we are typically able to figure out most of these things up front. I can't say with 100% assurance because things do happen. For instance, and I'll give you a for instance for that, and I don't want to muddy the waters or anything, but we've now started seeing, we've had a couple of cases where support was set in a dependency case, and there were competing orders in the dependency, in a dissolution, and a child support case, and we had to go through 4 or 5 hearings, Mr. Castro and I, and the litigant, and then an attorney became involved, which I think is in the room right now, if I'm incorrect, and we had to basically have 3 or 4 hearings to figure out, I hate to go back to this, but who's on first and what's on second.
Right.
And that's a problem. So, let us know about the problems up front, and we'll try to resolve them. But that is another issue that lawyers should be aware of, and I want to raise that now, is make sure that when you're doing this, you're involved in these types of situations, and there's a dependency case or a domestic violence case, that there isn't a competing order of support that we should be aware of.
All right, so the underscore here is that the reason that we're being such pains about this is not because Judge Barber and I don't like to deal with child support. That's just a happy coincidence. The reason that we're doing such pains about this is because once you guys are out of the case, your little folks are left with 2 orders, which can lead to 2 income withholding orders. We'll talk about that in a second. And just retroactive in both cases, and it's just a real mess that ultimately we're going to have to fix and you won't be around for.
Or, if I can just
Yeah.
add, or this is this typical scenario, they come in on some type of enforcement that DOR has initiated, normally typically a driver's license, and they'll come in and they'll say, I've been paid. And look at the printout from our case, and there's no payments, and they'll say, no, but I think I have an order, I don't know, because lay people really don't understand the distinction sometimes, and then we'll have to try to figure out what happens. That's really when it either comes to enforcement or modification, these are typically found out.
All right, and so what happens when one of these lawyers has a client that comes in that says, we just moved here 2 years ago or last month, or 6 months ago, whatever, from New York, and I've been paying $4 a month or something in New York, I don't know, I've got a piece of paper, it's not real clear, I think there was a case, it has a long number, I don't know. Where do they take their child support problems then?
Hopefully not to the 3rd floor, but no, I think that those individuals have to be directed to the Department of Revenue, because the Department of Revenue is really, that's their main focus, is enforcement of orders and modifications. You're starting, in that scenario, you're starting to deal with WIFSA problems that may occur, enforcement problems, or things of that nature, so they really should be directed to the department, unless the fire attorney wants to become involved.
Yes, so Judge Barber has whispered my favorite word into my ear, and that is jurisdiction. I don't want to get ahead of ourselves because I'm not going to talk about jurisdiction yet. It's coming. But first I want to make sure that everybody understands that you're going to see two kinds of Department of Revenue type child support things. One thing is going to be when the Department of Revenue, on behalf of a party, typically the custodial parent, it doesn't have to be, but I'd say that's 99%. You're going to see open case with the hearing officer that's running parallel to your case, or that's from years ago that everybody has forgotten but is still out there in the ether. The other type of order you're going to see your clients might be waiting around is an administrative support order. You need to read 409.2563. It's in your materials. Just remember, you need to read it. Mr. Pastor, in a nutshell, tell these folks what the difference is about that, even though that's not something your office actually gets involved in. But they need to know that your office isn't involved in that, and what it is they might do when they see one of those in their cases.
An administrative support order is an order which has been gone through by the agency. The agency renders the order and it becomes a support order. And it's enforceable in the exact same way that any other support order is enforceable in the state, except for by contempt in front of the court. So the only remedy that's not available to the department in those cases is the remedy of contempt in front of the circuit court. Now, this is a process that the agency goes through in order to establish a support obligation when there is no prior support obligation. And what they do, according to that statute, is that they notify the individual that they're going to start a support proceeding against them. They get service over the individual. Service in this instance can be done either by certified mail or by sheriff's service. Once they have service over the individual, they advise the individual within the service notice that they have options and what the options are. And when you read 409.2563, you will see all of the things that have to be included in the notice of commencement. One of the things that's included in the notice of commencement is the right to opt out of the process. This is important because if your client comes to you, you need to exercise that option at that point if you want to try this case in circuit court and not in the administrative process. They have 20 days within which to take two options. One, either tell the department, I don't want to play with you here, file in a circuit court. In that case, they are sent a waiver of service and they have to return that waiver of service within 10 days for us to then have personal jurisdiction over them in circuit court without having to serve them again, and then we will file in circuit court. The other option is to file within that 20-day period, you file your own action in the circuit court. What I see happen a lot of times is that you go and file that action in the circuit court, but do not let the Department of Revenue know that you have done that. And when that happens, the department thinks you have ignored it, and they proceed then to, with the process of sending your client a proposed administrative order. So that's the first part, the first opt-out. And the statute requires that if you do file an action in circuit court and there's an administrative proceeding going on, that you notify the department of that and serve the department with a copy of your pleadings. You need to understand as well, and I don't want to jump too far ahead, but you need to understand that the department is the only agency in the state that has a specific statute for service of process. It's 48.111 subsection 3. And that says that the department has to be served in Tallahassee on the deputy agency clerk. It's really important that you do that, because then that preserves all of your rights once you have done that.
So that is in your materials as well, that statute. So Mr. Castro, I think the most typical scenario is not that your client comes in and says, I just got this in the mail yesterday, luckily you've got 20 days to respond. No, they come in, it's dog-eared, it's got 14 years worth of coffee on it. It's that shift has long since passed. So what happens when they bring in their administrative support order that says, dad is to pay $300 a month, and they want to change that. They want what that statute calls a superseding order. A, what do they file? Where do they file it? Where do they file it? And who hears it?
Well, can I answer that?
Please.
Okay, that's 49256.310C, and you really need to read it. That is the provision that provides for superseding order of administrative order. Where it's filed is the county of residence of where the petitioner resides. So they have to file it where venue is proper and the court has jurisdiction of the party. So you've got to determine your venue issue, and you've got to determine your jurisdiction issue. And at that point, you may enter. Hello?
What statute?
409256310 sub C. At that point, what happens is you have filed your action for basically a prospective order moving forward. The important part of that statute is whatever arrearages have accrued under the administrative order cannot be modified. So they're vested at that point for all intents and purposes. So if your client has not been paying under that administrative order, the court does not have the jurisdiction to modify any of the arrears that are already vested. And typically, in most cases, the administrative support order has been filed, and including Osceola County, in the circuit where the respondent resides. So there'll be some sort of a record made, but that arrearage issue has to be determined. Repayment of that arrears now, however, does vest in the circuit court. So anything accrued is fine.
So if say there's an old administrative support order that's been ignored for many years, parties come in and there's a paternity action, nobody brings it up, it gets figured out before the final hearing in front of the circuit judge. Can the circuit judge enter a superseding order on that administrative support order?
Yes, I mean, you could enter a prospective order for the amount of child support as a guideline.
So here's my question. That paternity action will not likely specify, I'm requesting a superseding order to modify this administrative support order in case number blah, 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 blah. Can I still enter a superseding order even if they don't request it specifically?
Yes.
All right. And that needs to be sent to the department, or they will not know.
Correct.
Okay.
The department should have been served.
All right, so here's some softballs for you, Mr. Gass.
Okay. Nice softballs.
The lawyer gets involved in the case. It's an old case, it's a real old case. And it's been dealing with it's a petition for paternity brought by the department for child support. Can the lawyer, on behalf of the respondent, file a counter petition asking for time sharing?
No.
No.
We have an administrative order in this circuit that says that the parties shall file a separate petition for those issues. They cannot be filed within the context of the child support case.
And you can't file it as a counter petition and then figure, well, it'll just get bounced over and the circuit judge will deal with that part of it. You can't do
It
it.
will be dismissed.
It will be dismissed. I want to talk about jurisdiction for a little bit. There's some stuff that we haven't covered that's in your materials, but we're going to move on here. Two things about jurisdiction, my favorite topic, I'm going to keep it real short. When it comes to, I have this order maybe out of North New York. In Massachusetts, I was paying child support. We just moved here from Texas. Oh, potential client, was there an order there? I don't know. I don't think there was an order. Were you paying anything? Well, I don't think I was paying anything. Was something getting taken out of your paycheck? Yeah. Yeah, I was paying like $20 a week or something. you can, and we're gonna talk more about domestication in a minute, you cannot bring child support here in Florida unless you have a grounds for jurisdiction, because that state keeps exclusive jurisdiction over that matter until a lot of things have happened. And in the case of child support under 88 some or other, not only do both the parties have to be gone from there, but even more than that. So just pay more attention when you're questioning your clients if you don't get bad news when you get to the hearing and we're asking questions that turn out you can't give the relief that you wanted to. Go ahead, give me a point. Yeah.
It's just a point of practice, and I'll take responsibility for this. Chapter 88 is a really difficult chapter in the Florida statutes. It's very difficult to understand. I have many instances where I have to rely on Mr. Castro to give me information that I need about 88 because it's very difficult to understand. So if you have a multi-jurisdictional situation, fall back to 88, do some research, and see if you can file anything within the parameters of Chapter 88. I really would stress that. And I can tell you from experience that it's not only a difficult chapter for the attorneys, but it's also a difficult chapter for judges and for hearing officers. And we continually have to update ourselves and reacquaint ourselves with the statute. So I would urge you to do that.
All right, so now we're going to talk about a two-part topic. I'm going to talk about the first part, Judge Traver's going to talk about the second part, and that is paternity, DNA testing, disestablishment.
Hey, Judge Tennis, do you
Yes.
want to take any questions
Oh,
on
I'm
the
sorry,
DOR
thank you so
stuff
much.
first?
Thank you so much, thank you so much. Judge, do you have any questions on that end?
Do we have any questions at our capacity showing in Orlando? Ms. McMitchin?
Yes.
And I'm going to repeat the question afterwards, just so everybody can hear it.
Judge Dennis said that the laws are the same, but the laws are not the same in regard to a very near and dear issue to every person in this room, which is attorney's fees. And 61.16 does not apply. And so why is it not unconstitutional that when a person who makes $150,000 uses their services for modification and sues somebody who makes $30,000 and there's no way for the person with $30,000 income to get attorney's fees as they would on the 16th floor?
All right, so Ms. McMitchin asked.
I heard the word
You got it?
I heard the word unconstitutional, which means you're going to be answering this, so word it however you like.
Yeah, it's not a softball, hearing officer Katz. The question, and Dottie, correct me if I'm wrong on any of this, her question gets to the idea of attorney's fees, which is that you can recover attorney's fees in one venue, specifically if you're appearing in front of a circuit court judge and not in another venue. And her question is that we have income disparity and the people are forced to go to a situation where they cannot recover attorney's fees. Why isn't that unconstitutional or otherwise wrong? And I'm going to step aside for that answer.
This is the first time I've ever dealt with a law constitutional issue in a very long time. I'm trying to understand the question is, do the hearing officers have the ability to assess attorney fees against the department or the litigants? Is that the question based on income disparity?
That's the genesis of the question.
I think there is, and I'll speak to Mr. Castro, I think there is a statutory bar to do that. And I don't think that's permissible. Whether that's good public policy or not, that will have to be in the eye of the beholder. Is it constitutional? I don't think it's ever been challenged, and if it has, I'm not aware of it. I can certainly look into that, but that's never been a question that's been raised. And I would see to Mr. Castro if he has anything further on that issue. I've tried to answer it the best I can, and no, this was a pretty 95-mile-an-hour pitch, by the way.
Mr. Castro, correct me if I'm wrong, in an extreme situation, does 57-105 apply potentially? I believe that it does. But they just don't, you just can't use the need ability to pay in 61, is that correct?
6116 specifically exempts or takes out attorney's fees against anyone who is not a non-prevailing obligor. So you have to make a decision as to what, during the litigation, who prevailed, and two, who the obligor is. If you have a non-prevailing obligor, you can assess attorney's fees. You cannot do it if you have a non-prevailing obligee. So if the person to whom support is owed did not prevail, you cannot assess 6116 attorney's fees against that individual. 57105 fees are permitted against anyone in a Title 4D case. So I think it's a matter of policy. There's one case that dealt with that issue in a very interesting way. There is actually an opinion and then another opinion on a rehearing is cited in your materials. It's the Spano versus Cruz case, 62 Southern 2nd, or Southern 3rd, in page 2. In that case, there were two opinions. In one case, they were not entitled to attorney's fees, and in the second, the rehearing, they were entitled to attorney's fees. So it's an interesting thing, but I guess it's just a matter of policy. They did not address the constitutionality, Ms. McMitchin, of the statute, but they certainly apply it.
So I'll just segue into when we have our next seminar, which will be September 22, our topics will be attorney's fees and evidence and advanced trial practice issues, and we will try to cover that a little bit more. Does anybody on your end have any other questions that aren't Ms. McMitchin?
You're up first.
I have a question. Assuming that child support is established in a paternity DOR case, and then the non-custodial parent files a petition to establish a parenting plan and modify child support based on that parenting plan, is it my understanding that they would have to file a separate proceeding to modify, to establish a parenting plan, and then once that is established, go back to the DOR proceeding and file a separate proceeding to modify child support?
We heard the question, and I think the pitch is slowed now. The answer is yes. That's exactly correct.
So, and I think the better course would be to file the petition to determine time sharing in the circuit court. And then once you've got that time sharing schedule, file the petition to modify in the other. Now, I've certainly seen it where you file both in the circuit court. We catch it, we come in, we say we're only doing time sharing, you take that order, and then set a hearing on the petition for modification in front of the hearing officer. But I think it's much cleaner to do all the child support in the DOR case and all the time sharing in the circuit court case. Please.
Just one other issue that everybody needs to be aware of, and I don't know if my brethren from Orange County are there in the room, but we have started, based on the changes in the statute, where you now, in the old days, it was the only way to deviate for time sharing was with an order, and now we can do it in several other ways if there's agreement of the parties, if they've been exercising it for a period of time. So we have started dealing with time sharing and asking those questions in our hearing. So I want, when you go to do your time sharing schedule, please be cognizant of the guidelines in the initial case and take a look at them, because I would hate to be in a situation where the parties were exercising more than 20%, whatever the percentage was, and they go get an order for whatever reason because they both want it in writing, and they now come back for modification thinking that they're entitled to modification because now they have that order. If we considered it in the initial proceeding, the attorneys need to be aware of that to make sure that we don't have to say, no, we've already dealt with that.
I've got one more question in Orlando.
Okay.
Thank you. Are you aware of any way to get an arrears canceled or reduced if there was an administrative support order entered? For example, some guy gets that order, moves back into his girlfriend, they quit for 5 years, they break up again, and now he owes $20,000 when he's been paying support all along.
So the question gets to the administrative support process, and the question gets to whether or not there is any device by which past arrearages can be modified based on a change of circumstances that happened during that time. For example, the example that was cited was that the administrative order is put into place, and thereafter the parties move in together, and the person who is required to pay under the administrative order, support order, starts providing daily support by living in the same house.
All right, I'm going to start this, and then I'm going to have Mr. Castro take over if it's okay with you, Judge. I would cite, again, going back to 409-2563-10C, and it states, any unpaid support owed under the superseded administrative support order may not be retroactively modified by the circuit court except as provided by 61.14 sub 1, so sub A. So there is a possible exception, and I'll let Castro kind of discuss that with you all.
When you get to the issuance of a superseding order, the judge has to do two things. The judge has to calculate the new ongoing child support, and for it to be a superseding order, it has to be different from the administrative order. If it's the same as the administrative order, it is not a superseding order. Be aware of that. Secondly, the other thing that the judge has to do is to adjudicate the arrearages which exist. Now, adjudicate the arrearages, I think, means to make a determination of what those arrearages are. To the extent that there is no money assigned to the state, even if the mathematical calculation that the court arrives at is different from what the clerk of the court's records say, you're not going to have an objection from the department. If you are then getting rid of any money that's assigned to the state, they're probably going to ask me to come in and say, Judge, you know, the parties might have had the right to do away with monies that were owed to them for whatever circumstances or for whatever reason, but they didn't involve the department, and those monies were assigned to the department. So I'm going to ask that that portion of the order be set aside. As a practical matter, I think that the circuit court can adjudicate the arrearages in a total adjudicated hearing with due consideration to whatever the circumstances that existed at that point.
All right, so I take that Mr. Castro is inviting us to kind of ignore that part if the circumstances call for it, if equity demands it, and as long as that order gets sent to the department and they have a chance to say, hey, wait, yeah, it may not have been fair because they're living together again, but she's still been getting money from the state claiming that she's poor and alone in this world, so we need some of that money back. Is that essentially what we're saying?
I think you have the jurisdiction to do that.
All right.
Okay, I have a question then. Let's say that the administrative process is ongoing or it has finished and there has not been a circuit court activity, a superseding order filed. Is there any process by which the parties, the litigants, can go to the administrative process to modify the administrative support?
The answer is yes. Actually 2563 sets out the process where they can go back to the administrative court to get a modification or any type of relief. So the answer is yes.
Good. All right, any questions on this end? Yes, right here.
One quick one. Going back to child supports established in DOR, separate petition for the time sharing in circuit court enters an order, they need to go back to DOR to modify that child support. The date of filing the petition for paternity is the date upon which the DOR can go back to modify them.
Okay, this is a great question.
Yeah.
You've got a DOR order.
We heard it.
Okay, you heard it?
Yeah, we heard it just fine, came through loud and clear.
So,
Answer.
in a typical case where you now set time sharing and you come back to petition to modify, I think the statute on modification says you go from the date of filing of the petition to modification. So you can't let a lot, I understand what you're going here.
That's a problem.
No, that is the problem.
That is a problem. Typically, I will tell you with Ms. Castro that if we're in in that situation, if the payee doesn't have any problem, I'll go back to the date of the entry of that judgment of timeshare, or by agreement of the parties. But if we're going back to what Judge Tennis was talking about, typically a lot of times we get people still continuing to receive some type of state benefit, and then they want to go back when they haven't followed the right procedure.
But you could file your petition for modification at the same time that
Well,
you file.
that's what Attorney Redding has
You
suggested.
just have to make sure you get your
Right.
time sharing order first.
That's good practice.
But then you have to be prepared that you may have to dismiss your petition or withdraw your petition for modification if you go in front of the judge and the judge does not change the time sharing. If
Well,
it's denied,
I mean, you'll have to
then
do
you're
a little
gonna have
extra
to
work,
withdraw.
and you'll have to take a dismissal, but it might be good practice, to do that.
Yeah, but really good question. There was some, yes, sir.
Thank you. My question is, it concerns the attorneys when they go to mediation, but likewise, as a mediator, when there are pro se parties, whenever the issues of child support with respect to being ordered previously by DOR are concerned, how best should they be written up in the agreement?
Okay, this is a fantastic question. Thank you for answering it. This is a huge area of problem because people want to do what people want to do, and they don't understand any of what we're talking. We barely understand it. I mean, they don't understand it. So, my preference would be that as a mediator, you tell those pro se people, you've made me aware, or I'm aware that there's a Department of Revenue case dealing with child support. You've got to go back there. And in the agreement, say they want to modify. In the agreement, I would prefer it say, the parties understand that this agreement as to child support will not be incorporated into an order by the circuit court, and that they will have to take up a modification action or some other type of action in the DOR case number, blah, 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 blah. And then they've got something in writing that tells them that that this order is not going to affect that. We have just changed the pro se final judgment of paternity form in that situation to make it even more clear to people that agreement you made is useless. It has no legal bearing whatsoever until you go back to the DOR case and make that modification. So if we could have mediation help us send that message, I think that's going to save a lot of confusion for people. Does that answer your question?
Respectfully, I would say yes and no.
Okay.
It doesn't necessarily answer and I would look to any help from the mediators as well. Just because, for instance, if there's an entitlement, that I understand that the state needs to be repaid. But if there's not an entitlement, should we still, what I was doing was just generating, filling out the time sharing, figuring out how much it is, running the guidelines, and then saying something like, there is an existing DOR case, this is the case number, and then saying this is how much child support has been calculated at for determination by the court.
Now,
Yeah.
this is it's been a problem for me, and we've discussed this internally here. All due respect, I think you're treading dangerous waters when you start making determinations as to entitlement or non-entitlement. And I think the best practice would be for a mediator to do exactly what Judge Tennis has said, to say if there's a previous DOR order in effect, that's binding and that you're not going to enter a different amount up until it's properly pled in an action in the circuit court action dealing with child support. I would really think that mediators should stay away from that issue.
In that instance, it would be the better course of action, not even to run child support guidelines.
Right.
So,
Exactly.
I don't want them confused. Yes. So it's not about whether or not that new number is okay or not. It's that the parties are going to think that their agreement is going to have legal effect in the circuit court case when it isn't going to have legal effect. I'm gonna see that there's a DOR case, I'm gonna scratch through it on the final order. They think they've got a new number, and they don't have a new number. So it's not so much that any of us object to that new proper guideline amount being implemented, but they think it's gonna be implemented with us, and it isn't. And I want them to know they've gotta go that extra step and file something in the DOR case. That's the part that I want made more clear to them. Not necessarily that you shouldn't go to that effort. Any other, yeah?
Judge Spence, doesn't this event and some of the other issues you're having trigger, why not file a notice of related cases right when you know there's a new case? And my question is Hearing Officer Katz getting notices of related cases? Because if those are properly being utilized and updated as cases are discovered, everybody should know that they're orders.
Well, I'll answer that question.
Did you hear that?
Can we do that one more time, or
Yeah.
repeat it, please?
The question is, why isn't somebody, i.e. clerk's office litigant, somebody filing a notice of related cases along with either the DOR case or the family law cases so that everybody knows in a document that there's a competing Department of Revenue case?
Well, let me answer it this way, and I'm not sure if you were in the room when I answered this question previously, so I'll just say that, but we typically check when we get into a hearing whether there's any related cases. And typically, I check and then I'm double checked by my trial clerk, who's very, very good at it, and she'll let me know right away, and I'll say, stop, Ms. Castro knows, everybody's got a rhythm, let's look at it, or the attorney that's sitting there will look at it, and then we try to figure it out and not compound the problem. Where the problem has existed before in this is when the parties come in, because we were not having that dialogue with, we were not having that dialogue with the mediators, that child support was being set in the subsequent case, and then enforcement was being made in the first case, and then somebody brought in on contempt and said you weren't paying $100 a week. Well, I have an order for $75 a week, and I was paying the $75, and then we've got competing orders. That's the typical way.
So I'm gonna move on because I want to say just a few short things about the DNA testing, because this has been a big issue. Understand the hearing officer hears undisputed paternity cases. If your client or if the father is on the birth certificate, he's signed an acknowledgement of birth, he hasn't done the rescind that within 60 days, he is presumptively the legal daddy. So when he files a motion for a DNA test, that does not make that a disputed paternity case, number one, so it stays in front of hearing officer Katz. Those motions flow from the guy who filed it to, in Osceola County anyway, to the circuit judge. The first thing I do is I look it up. If it's clear from the record that he signed the acknowledgement at birth and he is legal daddy, then I deny them. You don't have a right to a DNA test. You do not have a right to a DNA test if you sign the acknowledgement of birth and are on the birth certificate, or if you're married to mama. You're a legal dad. You do not have a right to a DNA test. You must, only way out of your child support obligation is through a petition to disestablish. If there's a DOR case and you want to file a petition to disestablish, you cannot do it. Just like you can't file I want time with kid, you can't file I don't want to be dad in the DOR case. It has to be a separate action. It's a paternity action, it's kind of an unpaternity action, but it's got to be a separate action. So if DNA tests, we're not giving them out like candy. You don't get them. You don't get them if you're legal daddy. Judge Trevor's going to talk a bit about the petition to disestablish that needs to be done if you want to get out of your legal obligation.
All right, it's 1 o'clock. Can people stick around for 15 more minutes or so? I have to.
I haven't given them the number for CLE, so they'll be here on this end, I know.
I can stay until 20 after. I've got a 1:30 hearing, so I'll do this a little bit quicker than I intended to do it, which should be a relief to everybody. All right, I want to talk about disestablishment of paternity, and I want to talk about it primarily in the context of 742.18, which is the disestablishment statute. Now, this doesn't happen terribly often. In all of 2015 in Orange County. Hey, Judge Dennis, can you mute on your side of things?
No.
Do you have the mute button over there?
No.
Okay, never mind then. This is only done 20 times in 2015, so it's few and far between. It's a pretty rigidly constructed statute, and when you take a step back and think about it, it probably ought to be. I mean, the intent, and the statute isn't too old either, it was just passed in 2006. The idea behind it is that you have somebody who has been adjudicated or is legally presumed to be the father of the child, setting aside and saying, I am no longer the father. So the consequences here, at least for the kid or kids, is pretty high. You know, you're not just looking at the loss of a potential economic support source, you're looking at potential illegitimacy, and both the legislature and the court systems have said that they're not really fired up about doing that without really good cause. So to echo what Judge Tennis said, if it's birth certificate plus 60, or if it was an intact marriage, you can't just go asking for DNA tests. The way that, again, that I'm going to be talking about this is in the context of disestablishment. There's also a provision under the regular paternity statute, which is 74210, which talks about fraud, mistake, or duress. I'm not going to speak about that too much, other than to say that when they say fraud, mistake, or duress, it doesn't mean conspiracy. In other words, fraud does not equal conspiracy. Fraud does not equal two people saying, hey, we're going to have an agreement that even though we know you're not the father, you're going to sign the birth certificate anyway. You can't change your mind afterwards. Mistake is not an innocent mistake. It's not a fake mistake, if that's the best word to describe it. Also, notably speaking, if there's a default situation, meaning that for whatever reason you're adjudicated, even though you didn't appear in, say, a DOR action, you can't then appear and ask for your DNA test. You have to go through the disestablishment proceeding, or you have to try to assert that there was fraud, mistake, or duress. So it's a pretty tough hill to climb, and if you're considering doing any of this, this is the initial takeaway. Now, 74218, like I said, hasn't been around for too long. Not too many people sue under it, so as a result, there's not a very big or robust body of case law about it. And as I'm about to talk about, the two main cases about it, one of which comes from the first DCA, one of which comes from the second DCA, come to two completely different conclusions. So we'll start with the statute. The statute basically says that if you want to disestablish, you've got to do a few things, specifically three. You've got to attest that there is newly discovered evidence, and you need to file it. The big fight over the DCAs concerns what newly discovered evidence actually is. You can assume it's going to be a very fact-intensive inquiry, and if I can take anything from the case law that I reviewed, it's probably better to be a little bit more detailed as to why your evidence is newly discovered when you're going to file your petition. Secondly, you have to file the results of a DNA test. Is there a disconnect about not being able to get a DNA test through court order, yet having to go get one privately before you can file a petition for disestablishment? Yes. You have to file that DNA evidence within 90 days of getting it. Third, you have to file an affidavit saying that you're current with any support obligations. After you have discovered this newly discovered evidence, there's an additional bar. You cannot proceed forward with a petition for disestablishment if after you've learned that you are the father via newly discovered evidence, you do a few different things. You marry the person, you acknowledge paternity under oath, you consent to be named on the birth certificate after this newly discovered evidence, you promise support in writing, and support's entered based on that promise, you ignore a state request to go get tested, or you sign a voluntary acknowledgement of paternity. A lot of these things are really self-explanatory, and it's basically, think of it as statutory estoppel. The idea that if any one of these things happen afterwards, they're not going to let you go and disestablish. The big issue comes to the question of what's newly discovered evidence. There's two cases. I'm not big on case sites, but if you are going to understand disestablishment of paternity, I'm going to give you two cases. They're a total of 10 pages long. I would highly suggest that you read them. The first one that was decided is called Hooks, 71 Southern 3rd 908. 71 Southern 3rd 908.
It's in your
That's the
material.
first.
Yep.
Wonderful.
We got it.
Second one is PG versus EW. That's the second DCA case. I'm going to do them in the order in which they were decided, which is 55 days apart. And basically the facts are going to, again, be very, very important. In Hooks, child's born in January of 2005. Dad does not go on the birth certificate. September comes along, dad's name is added with his consent. Perhaps in related news, a day later they get married. And the reason that they get married is because the dad is in the armed forces and he wants the child to have the benefit of his benefits. Now, before he signed the birth certificate, Mr. Hooks knew that there was only, quote, a 50-50 chance, unquote, that he would be the father. Basically, they were in an on-again, off-again relationship. They were both seeing other people. Their love was not meant to be, and in 2006, they get divorced. At that point, they're 18-month marriage. 3 years later, he files a disestablishment petition. He went and got a private DNA test, and he found out, indeed, he was not the father. Now, what the first DCA says is that DNA test is not really newly discovered evidence. It's not newly discovered evidence, even though you just newly got it, because you knew that there was only a 50-50 shot that you were the father. And basically what the first DCA says is the only thing that we have to go on as to what newly discovered evidence means is the rehearing statute, 1.54 of the Rule of Civil Procedure. And what that says is newly discovered evidence means stuff that you didn't know about or couldn't have known about at the time that you litigated your underlying action. He knew that there was only a 50-50 shot. That was his window to get his DNA test, so therefore it's not newly discovered evidence. They also said that as a matter of statutory construction, why would we have newly discovered evidence and DNA requirement in separate sections if one automatically equaled the other? Okay. 55 days later, the second DCA completely disagrees. This is a terrible case in terms of a factual pattern. Parties aren't married when they have their son in 1994. Dad ultimately signs the birth certificate and they get married in 1996. Their love was not meant to be. 10 years later, they get divorced. They agree in their divorce that it's their child. And they have a trial about it. And dad is awarded primary residential responsibility. So the son is living with dad. 3 years after that, the 15-year-old child starts having mental health and behavioral issues. Dad attacks the problem by getting a DNA test because nobody in his family has ever had mental health issues. The DNA test shows that dad is not the biological father of the child. So while this child is living with the father, he goes and files a disestablishment action. The trial court, perhaps unsurprisingly, based on what you've already been told, says, no dice. You're the father because essentially you're stopped from raising these types of arguments. The second DCA takes a very specific and hard look at the statute and says that when we look at the idea of whether evidence was newly discovered, this DNA test constitutes newly discovered evidence. But they go one step further than that. They say we disagree with Hooks, and a DNA test is newly discovered evidence as a matter of law. They certify the question to the Supreme Court, where of course the Supreme Court never chimes in because they're never officially asked to do it. So the effect of this on you guys, and I say that globally across the circuit, is that you have two separate DCA opinions, which say two different things about the importance of a DNA test. Neither of them are going to be binding on any of the judges that you're looking at right now. So how you phrase that petition and the facts that you adduce in that petition, I think, are going to be exceptionally important. Any questions on y'all's end first? On Osceola's end?
Any questions that you all have? I don't believe so.
Any questions on the Orlando end?
What if you had a case where 10 years ago, she was running for me, mom obviously already pregnant, love is in the air, the baby's born, there's no time for and they break up a little bit later, 10 years go by, they have no contact at all. Then 10 years later, Harper resident comes looking for his dad, he's like, oh wait a minute, dad is possible. But at this point, both parties are saying, no, he's not the dad. Is there any way to do a disestablishment paternity by consent of both parents, because the biological mother is saying, no, it's not dad, I don't want it to be dad.
So Ms. Demps, outrageously difficult first questions are running in the family. It's nice to see. She says she comes by it naturally, I agree. The question, if I can rephrase it, is a situation in which two people meet one another. The woman is already pregnant, and they get involved, they get married, and the child is born into an intact marriage.
So they never got married.
They never got married, but he signs the birth certificate.
They never got married.
All right, and then 10 years later, they decide to go their separate ways.
They got right after the baby was born, so they were apart for 10 years. They never really lived together, didn't raise the child.
All right, so they break up right away, even though his name is on the birth certificate and he knows that he is not the father. That 10 years later, he goes and files a disestablishment petition. And your question is, can he disestablish under those facts? As a consented disestablishment, and your question is specifically, can it be done through the Department of Revenue?
And specifically, can you disestablish paternity in that situation where both parties consent? Where the mom can say, I don't want you to do child support, the Department of Revenue may want you to do child support, but I don't want you to do.
So the case law is, and I'll actually ask the judges and the hearing officer down there to chime in on that, because
Right.
I can tell you quite honestly, I'm not 100% sure of the answer. But if I look to the statute, which requires strict pleading requirements, I don't think he can, because there's no newly discovered evidence in that regard. Now, you might be able to make the technical argument that, hey, we had a DNA test now, and under the second DCA decision, this is newly discovered evidence. But I think, and this is just one person's opinion, that if the fact pattern is as you outlined it, and this person knew 100% that there was never any chance, but he signed the birth certificate anyway, I don't know that that would be persuasive even to the second DCA. Does anybody have a different opinion?
So I totally agree with you, and I don't believe that a consent of the parties would have anything to do with anything. Now, if mom happens to have a new husband who's ready to step up to the plate, and they want to do a step-parent adoption, but you gotta have, we're not having daddy less just because it's convenient for the parties. I don't believe.
Or is bio dad, I think, if the bio dad wanted to be father, I think he could be.
What Ms. Lomas said is that if you had, and it's kind of chiming in on what you said, Judge Tennis, is that if there were a handoff,
Yeah.
whether it be done through Daniel or otherwise, that might be doable, but probably not through disestablishment.
Right.
Does anybody else have any easier questions here?
Any easier questions? Better me?
Yes, ma'am.
Oh, wait.
Yes, ma'am. Nobody here has any other questions?
Yes.
Just one quick question. You mentioned that there has to be an affidavit that the father or alleged father is covering child support obligations. What if there was a period of incarceration subsequent to the time that the child was born and he's therefore behind?
So the question is, what if there's a really good equitable reason that the person who's filing the disestablishment is behind in child support?
There's a good cause exception in that affidavit section.
Right.
And you would have to outline reasons why you weren't in compliance.
All right, we're gonna do, yeah, go ahead, please.
Just before you make that quantum leap, just check DOR versus Jackson to make sure that there's no indication in that opinion about this issue. Because my understanding of reading that case is that child support vested during a period of incarceration is still a vested right. So you might want to take a look at that case.
And that would probably be an exception, an argument to contravene the good cause requirement.
Right.
But yeah, there is a good cause exception if you want to make it.
All right, we're gonna talk just briefly about an issue that's been shown up here a whole lot, and that is what a domestication means and does not mean. Judge Barber.
Yeah, I want to talk just very briefly about foreign support orders. And when you see, we have a client come to you, for instance, and they have an action that's being enforced through the Department of Revenue, let's say. The Department of Revenue is enforcing a foreign support order. The Department of Revenue can do that and enforce it, but if your client wants you to modify that foreign support order. Do know that you have to look to jurisdiction. The issuing court retains exclusive jurisdiction over that support order until all parties have left that jurisdiction. Okay, and when all parties have left that jurisdiction, that doesn't automatically mean that Florida now has jurisdiction because one party lives here. For instance, if mom and dad and the kids are all in California, they have a California support order, and dad relocates here and mom relocates someplace else. Florida does not have jurisdiction in that instance to modify the support order. Now, if the parties consent, and allow California to transfer the jurisdiction, that's something different. But you need to really look to see whether or not there is jurisdiction, okay? Do know that Chapter 88 prohibits the state of Florida from modifying a foreign spousal support decree. That sounds kind of crazy, but there's a case in your materials where the parties had a Dade County spousal support decree. They relocated to Tennessee, and Tennessee said, I need to look to Florida to see if we have jurisdiction. And the Florida court actually transferred jurisdiction to Tennessee. It said, here, you modify this in Tennessee. And the wife appealed, and the higher court said it's clear that pursuant to Chapter 88, the issuing court retains jurisdiction, and you cannot modify that. So if you have a client that comes to you with a Massachusetts, Delaware, wherever, a spousal support decree, and everybody's living here, do not think that we have jurisdiction, because we do not. They have to have that modified. It doesn't sound logical, it doesn't sound right, but they have to have that modified back in the court from whence it came. Now, can the parties agree? Maybe everybody who lives here in Florida and then want to agree to modify the foreign support order. You can't confer subject matter jurisdiction. So I don't even think under that situation, if everybody was slap happy with it, they could do it. It would be a void order. So just a word to really look into jurisdiction and make sure that before you ask us to modify something, that we have the jurisdiction to do that.
So I'll wrap up with Tennessee child support order. Mom and kids come to Florida. Dad goes to Michigan. DOR is helping mom continue to get that child support. So you all think, child support, Florida, groovy, motion to modify. No. State 1 keeps exclusive jurisdiction, and even if they were to relinquish it, Florida does not have personal jurisdiction over dad the payer. You cannot get a modification here. The other thing that we want to make sure you're clear on, domestication has nothing to do with being able to modify. Nothing. Those two things could not be more not the same. Domestication means we have the power to enforce a foreign order, whether that's child support, time sharing, lots of other things. So when you want something enforced here, you do a domestication. Some situations, child support order, you can do a registration. I'm not going to get into the weeds on it. But domesticating it here does not mean you can turn around and file a modification. That foreign jurisdiction keeps exclusive jurisdiction until time sharing, everybody's gone, until everybody's gone. And even then, you've got to have subject matter jurisdiction over the children, and you've got to have jurisdiction separately from the domestication. Not only
Look to Chapter 55 for domestication, Chapter 88 for registration.
All right, I'm going to give you, I'll take a couple more questions on this end. Judge Traber, I know you have to go. I'm going to give everybody the CLE number. It is 160469N. 160469N. And Judge, do you have any last questions on that end?
Nothing. Thanks, everybody, for coming out. Actually, we got one more question, and she's been patient about it.
Sure.
Back of the room regarding DOR stuff.
Yeah, that's one quick question. One of the things that it's all about is right? So now we have been hearing about the DOR. So we have, I guess my question is, I have properly noticed the Department of Revenue in regards to acquisition of fraternity, and the judge is not involved now. Now we're having mediation, so the judge is not there to catch whether we can be involved with any child support or not. And now we have a private mediator. So the option of having the Department of Revenue easily accessible to the mediator is now not available. What is the notice requirement? So if I notice the Department of Revenue for the mediation and they don't show up, am I allowed to?
It's a mediation question again, which kind of offshoots what Judge Tennis was talking about earlier. And the question, if I understand it, is we're in a private mediation setting. Is there an ability, or what is the ability to notice the Department of Revenue as to the mediation where something might change? And more practically speaking, is anybody going to show up?
The more important question
And-
is now enforceability. So now we have to be able to have notice Department of Revenue.
Well, it's not enforceable until it's blessed. But let's just deal with the first one first, which is anybody going to show up? Is there any ability to notice the Department of Revenue for a mediation where something like this might change? And can they be a part of the process?
Mr. Castro?
You can notice us if we get a notice, for example, in my office that you're taking some sort of action in the case, I will send that to the Department of Revenue and ask the Department of Revenue to either refer that case to my office to participate in it. We'll look at that case and determine whether there are any assigned rights to the state. If there are no assigned rights to the state, and the parties are going to go into mediation and settle their differences, we will not have any problems with that. More likely than not, we will not show up at the mediation.
And so you've done the notice, as long as you've noticed them, that in the paternity case in front of the circuit judge, you're going to mediation, you want to deal with child support also, which is in a DOR case, you've let them know, they made a determination that they ultimately don't care what number you come to. That is all great, but you still are going to have to get that agreement blessed in front of the hearing officer in the DOR case, as well as the time sharing in the paternity case. You're still going to be dealing with it separately because that order needs to be separate, even though you're probably not going to have any problems at that point. It still has to be done in both jurisdictions.
I guess my question is, the Department of Revenue doesn't respond. So I've noticed in Tallahassee that we have this petition fraternity. I've noticed the Department of Revenue, and they don't give me anything. But they're
Can we take your question just after this is all set? Because we got everybody who's got to head back to different things. I think we're good here, and then I'll have somebody come up to the mic afterwards to ask Mr. Castro this question.
All right.
Anything else down there?
I think we're good down here. Thank you, Judge Traver.
Thank you.
Thank you, guys.
I got back in December.